So I've discussed timetable with my friend. I'll be finished by 4, if not earlier.
I think 4 will have to be a hard stop, because if Mr. Brinston-Stockham's going to have a sensible chance to reply, and assuming we are prepared to sit till 4:30.
So I did rather make that assumption.
And on that basis, it does have to be a hard stop.
It will be a hard stop, and I'll aim for before.
Great, thank you.
But in light of that, and in light of the indications before lunch about what can or can't be derived from my respondent's notice materials, I'm not going to spend more time on the respondent's notice point. Okay. All I would ask you to reconsider in terms of whether the Hansard report is an admissible aid to interpreting the 1998 protocol is what we said in our skeleton at paragraphs 58 and 59. So just for your note. It's to deal with the FTT's reasoning that this is a unilateral statement akin to a statement of practice of the revenue considered by Lord Justice Patten in the Irish bank case. We've explained in our skeleton why that's not an appropriate analogy. But as I said before lunch, my attempt to distinguish Irish bank has to be predicated upon the inference that when Dawn Primarolo came to Parliament very shortly after the bilateral negotiation and told Parliament what the provision was about, she had in mind the joint position, not some unilateral position. Can I then turn to ground 2 and to Milena Friend's core challenge, although to some significant extent I've covered the ground already both in my introductory summary and in dealing with the meaning of Article 12. Could we start just by going back to see how ground 2 is articulated in the amended grounds of appeal? That's core bundle, page 20, subparagraph 4, sub 2. The FTT, it said, erred in its construction and application of Article 12.5, and the Upper Tribunal erred in upholding the FTT's decision, brackets ground 2. In this context, the FTT erred in principle in holding that BLM's sole purpose was to realise a profit. That wasn't a proper and complete answer. B, by failing to take into account the fact that BLM's assumed ability to obtain the benefit was the only basis for BLM's acquisition of the SARD claim to have taken place at all. It's also worth having in mind how the case was put below. If one could look, please, at the revenue skeleton in the Upper Tribunal, which is in our supplementary bundle, tab 5, page 91. That's Respondent's Unagreed Supplementary Bundle, tab 5, page 91, paragraph 58, where this is said by my learned friends. The most fundamental error in the analysis of the FTT, which occurs in its analysis of the positions of both BLM and Sickle, was its failure to take account of the fact that the sole, and in any event a main, economic basis for the actual transaction in this appeal was the UK withholding tax arbitrage, resulting from BLM's reliance on Article 12.1. Although I'm obviously going to deal with how Mr. Brinsmead-Stockham now puts his case, which is somewhat different, my starting observation is that it is entirely hopeless to suggest that the FTT was unaware of or failed to take into account the basic economic point made by the revenue here. There are numerous passages in the FTT's judgment showing that it was well aware of the economics of the transaction and took those into account as part of its overall exercise of assessing BLM's subjective purpose for entering the transaction. I'm not going to take you to all of the passages, but it's clear from their findings of fact at paragraph 1641 to 1642 and following, and in its reasoning at paragraphs 174 to 178 and 184. So the answer to the core complaint identified in the passage I've just shown you is the one that was pithily given by the Upper Tribunal in its judgment at paragraphs 77 and 78. That's core bundle tab 8. Foot of page 107. Where the Upper Tribunal says the argument that the FTT failed to take account the existence of the arbitrage runs into the difficulty that throughout the decision the FTT showed a clear awareness of the economic effect to which HMRC referred. See, for example, paragraph 177. HMRC seek to escape from this difficulty by arguing that even if the FTT was aware of the arbitrage, it failed to feature sufficiently prominently in its reasoning and so undermine the cogency of its evaluative conclusion. The reasons we explain, that simply represents a disagreement with the FTT's evaluative conclusion and doesn't establish an error of law. It was, in our view, appropriate for the FTT to have regard to the fact that there were potential purchasers of the SARD claim for whom UK withholding tax would not have been an issue and for whom the UK-Ireland treaty would not have been relevant. And the reason that they say that was because of my learned friend Mr. Brimsmead-Stockham's point emphasised below and shown in that sentence in his skeleton I just took you to, that all that should have been focused on wasn't a market and the existence of other potential purchasers in the market, which my learned friend said was hypothetical in some way. It wasn't. But only the actual transaction that was undertaken. Can we also look at what the Upper Tribunal said on page 109? Under ground 3, paragraphs 85 to 86. They say, first, HMRC say that the FTT was wrong to conclude that its finding that the sole purpose of BLM in acquiring the SARD claim was to realise a profit was an answer to HMRC's case. That's exactly what Mr. Brimsmead-Stockham repeats in this court. The FTT, said Mr. Brimsmead-Stockham, failed to recognise that the profit was entirely dependent on BLM taking advantage of the treaty. There was no separate commercial purpose. This seems to us to be just another way of making the points relied upon under ground 2. It was evident that the FTT knew that the only way in which BLM could make a profit was if Article 12.1 applied. Of course it was aware of that. The FTT's evaluative judgment was that Article 12.1 of the treaty was the setting in which the assignment took place. BLM was not seeking to abuse the treaty. On the contrary, it expected that, as the beneficial owner of the interest, the treaty would apply to it in the normal way so that the interest fell to be taxed in Ireland rather than the UK. And we say that is a complete answer to this point. Can I then, with that in mind, turn to address Mr. Brimsmead-Stockham's arguments in some more detail? It's obviously common ground that the starting point is the unchallenged findings of primary fact made by the FTT. The key findings about BLM are in the FTT's decision at paragraphs 164.1 to 164.4. That is spread over 2.5 pages of the judgment, starting at page 191 of the core bundle and ending at page 193. And although Mr. Brimsmead-Stockham took you to paragraphs sub 1 and sub 2, I don't intend this as a criticism because there's only limited time for each advocate to make whatever case they want to. He did not focus on the very important points recorded or found as facts by the FTT at subparagraphs 3 and 4. And can I just say this in terms of the structure of the decision? As you see, the FTT very methodically finds a fact and then states a number of reasons for finding that fact, including in subparagraphs 3 and 4. But in fact, under the rubric of reason, sometimes the FTT makes statements that are actually findings of fact in themselves. So, for example, at paragraph 1644, in the penultimate paragraph on page 193, albeit under the rubric of giving reasons, there are a number of sentences that in fact constitute findings of fact. So, as regards the price which BLM considered that Sickle was likely to accept, although one of the factors, not the only factor, one of the factors which BLM took into account when setting its offer price was the fact that the SARS claim, were it to be retained by Sickle, would have had a much lower value to Sickle than it had to BLM. BLM also knew that the value of the SARS claim to Sickle was much greater than that retention value because of the number of people in the market for whom UK withholding tax wouldn't be a permanent cost. That fact would inform the price which those potential purchasers were prepared to pay, and hence would inform the Sickle liquidators' knowledge of the value of the Sickle claim to Sickle, of the SARS claim to Sickle when it came to their agreeing a price. Malone Friend repeatedly said the only factor taken into account by the parties was withholding tax, but that's not what the FTT held. And it's not surprising that the FTT did not come to that conclusion, given the evidence. Give me one moment. There's a point I was going to make later, but I think I should probably make it there. Yes. If you go back in the FTT's decision to 80 sub 15, this is recording the testimony of Miss Gibbons, the foot of page 164. This is recording her evidence under cross-examination in response to my learned friend putting to her in cross-examination an email which is for your reference at paragraph 79.6 from Miss Julie Nettleton of Grant Thornton, who were the liquidators of Sickle, to Mr. Sabharwal, Naveen Sabharwal, who was a member of the team in the European affiliate of DKCM in London, responsible for claims against Sickle. Just to explain, and this is one of the features of the factual landscape we haven't yet been shown. DKCM, Davidson Kempner, had a relationship with Sickle in two ways. The first way, which is the only way we've been concentrating on so far, was as the purchaser of the SARD claim. The second way was that it was itself a creditor in the Sickle liquidation and would form part of the creditors committee in that liquidation. And so some of the emails, particularly those involving Mr. Naveen Sabharwal, whose role is identified by the First Tier Tribunal at paragraph 78 sub 7, were received in that context. And I don't say that because it has any major factual significance. It just shows the dangers of picking on bits of emails by Learned Friend, on the Malone Friends approach, to try and drive a particular factual conclusion at odds with the FTT's careful factual conclusion, doing what Lord Justice Lewison in Fade and Chobani called island hopping. You can't island hop you've got to take into account the whole of the factual evidential landscape. And the reason for drawing this out is just to show you how so far that just hasn't been done by my learned friend. Anyway, going back to page 164 of the judgment, this is recording Miss Gibbons' evidence, foot of page 164, subparagraph 15. As regards the statement by Miss Nettleton, that's of Grant Thornton, in her email that's to Mr. Saberwell, to the effect that UK withholding tax was one of the factors which motivates the discussion around the sale of the claim, she postulated that another factor might have been the disappointment felt by Sickle at the unfortunate outcome to the Waterfall 1 litigation, which had led to Sickles making a lower return for this, that's the foreign exchange litigation, led to Sickle making a lower return for the SARD claim than it might at one stage have expected. This might have made Sickle less willing to retain exposure to the SARD claim, with its liquidation, lacuna and late termination risks, and more willing to get rid of the asset, the so-called seller fatigue. In addition, as Sickle was in liquidation, that too might have made the Sickle liquidators keen to sell the asset. And the reason I emphasise all of this is to put into context my learned friend's repeated assertion that the only basis for the transaction here was withholding tax arbitrage. It was not, and there was no finding to that effect. Frankly, even if that had been the position, my arguments would still be the same. I just don't want to be seen to be accepting what my learned friend repeatedly said. So, can we then turn back to the FTT's judgment at 1644? Could I just ask you to reread the entirety of 1643 and 1644? And I'm going to make some submissions. And then in conjunction with that, could you also look, please, again at paragraph 165, sub 1 and sub 2, which are relevant findings of fact about Sickle. So given that Mr. Brimsmead Stockham was at pains to emphasise, as he has to, that none of the primary findings of fact are challenged, his case has to proceed on the basis of the following factual matters, all of which concern BLM's subjective purposes, which is the key question. Number one, in the mind of BLM, the primary driver of the purchase price, that's the language of the FTT, the primary driver of the purchase price was the cash flows to which the SARD claim was expected to generate. 2, that the mind of BLM was focused on achieving an appropriate IRR, rate of investment return, and avoiding too significant a downside in the event that the late termination risk materialised. 3, that BLM, like Sickle, knew that the value of the SARD claim to Sickle in the Libby secondary debt market was higher than its value if Sickle had simply retained it because of the existence of a range of potential other buyers for whom UK withholding tax would either not be a cost at all or not a permanent cost. And 4, that awareness informed BLM's subjective decision about whether or not to acquire the SARD claim and the price, because it knew that if it sought to put in what Suzanne Gibbons called a lowball offer, Jeffries, who was, as Lord Justice Zacaroli identified, Sickle's broker, would then market the claim to other purchasers. So with all those primary unchallenged facts in mind, the FTT then set out its findings on Sickle's, I beg your pardon, BLM's purposes in the following paragraphs. First of all, it set out the legal approach. Well, I need to go back to the legal approach. Its evaluative findings start at paragraph 173 on page 198. And the core paragraphs in my respectful submission, which repay careful reading, I won't read them all out again now, are 174 to 178.
So that's FTT again.
FTT. FTT 174 to 178. I'll just annoy everybody if I read it all out, but those are really the core paragraphs of the FTT's evaluative reasoning. And in my respectful submission, for the reasons I'm about to give, these were evaluative factual conclusions about BLM's subjective main purposes, or sole purpose, that the FTT was clearly entitled, and we say right, to reach. And in particular, to confront Mr. Brimsmead-Stockham's core case, the FTT was not required to find that just because BLM couldn't have purchased the SARD claim at a profitable price, or a price that would have generated a profit, if it had had to suffer withholding tax as a permanent cost, it must inexorably follow, as he says, that BLM had a sole purpose or even a main purpose of taking advantage of Article 12. And the reason for that is because the FTT rightly recognised the core distinction between a party's subjective purpose in entering into a transaction and the economic consequences of that transaction. And it also rightly recognised that just because a party understands it will obtain a particular tax treatment, and I consciously use the word tax treatment rather than tax benefit, because this is a treatment under the distributive article. Just because a party understands that it will obtain a particular tax treatment and factors that into the price it pays for an asset, does not mean that it had a main purpose of obtaining that tax treatment. And all of that is supported by the following case law that I'm going to take you to. I'm going to start with my lady's judgment in Quickfit, largely because it recapitulates her earlier summary in BlackRock, although I am going to come back to BlackRock, and also because it considers Kleinwort-Benson. So Quickfit is Authorities Bundle tab 25. If we can go straight to page 628 for the time being, at least. But that's where, on page 628, under the heading "The Test for Unallowable Purpose," the judgment comes to the relevant parts for our case. So, paragraph 52, the judgment summarises Lord Justice Newey's approach to the unallowable purpose test in travel document services. See subparagraphs 1 to 3. And in particular, I highlight at the top of page 629 that it was the company's subjective purposes that mattered in accordance with the Brebner principle. And also I highlight at letter B that the question is subjective, and so what matters is the intention of the parties. Um, 53, my lady says, again as in BlackRock, uncontroversial that what matters is the company's subjective purpose or purposes in being a party to the loan relationship, or here the transaction. And nobody took any issue with the fact that the key person for present purposes was Suzanne Gibbons. That was her decision, and therefore her purposes that had to be ascertained. Then at paragraph 54, there's a recapitulation of the summary of the points made in BlackRock of how to ascertain a purpose. And in particular, I unsurprisingly highlight B, object or purpose must be distinguished from effect. Effects or consequences, even if inevitable, are not necessarily the same as object or purposes. And then F, it's for the fact-finding tribunal to determine the object or purpose sought to be achieved, and that question is not answered simply by asking the decision maker. Then there is a discussion of Kleinwort-Benson and its discussion by Mr. Justice Lightman and the Court of Appeal in the SEMA case. And in due course, I'd ask the court to read the whole of paragraph 55 to 63. But it's worth, particularly now for my purposes, emphasising what Mr. Justice Cross said in Kleinwort-Benson as set out at the foot of page 631. I don't want to take up too much time because you've seen it already. The learned friend showed it to you. It's the paragraph starting at letter H on page 631 to the end of that page, and then what Mr. Justice Lightman then said about that in SEMA as approved by the Court of Appeal. So it's particularly the last sentence on 631. In the same way, I do not think that one can fairly say that the object of a charity or a dealer in shares who buys a security with arrears of interest accruing on it is to obtain a tax advantage simply because the charity or the dealer, in calculating the price which they are prepared to pay, proceed on the footing that they will have the right which the law gives them either to recover the tax or to exclude the interest, as the case may be. And in this case, by analogy, the law, i.e. Article 12 of the treaty, gave BLM the right to be taxed in its state of residence. Merely calculating a price which they're prepared to pay for an investment on the basis of their understanding that that is what they were entitled to does not equate to taking advantage of the provision. And that was then echoed in Mr. Justice Lightman's comments, but just above letter C on the following page, where he says, obviously, if a tax advantage is mere icing on the cake, it will not constitute a main object, nor will it necessarily do so, merely because it is a feature of the transaction or a relevant factor in the decision to buy or sell. The statutory criterion is that the tax advantage should be more than relevant or indeed an object. It must be a main object. The question of whether that is so is a question of fact for the commissioners. Unless the commissioners misdirect themselves in law as to the test to be applied, their decision, as Mr. Justice Cross plainly thought was the case in Kleinwort-Benson, their decision can't be challenged. Can I then show you page 636. My learned friend Mr. Brimsmead Stockham yesterday was at pains to emphasise what my lady said in paragraph 87 on that page. But for my purposes, it's obviously important to remind the court what my lady said in the preceding 3 paragraphs, in particular at paragraph 85, where she said, I would agree with Mr. Ghosh that in most circumstances of that kind, there would be no question of the unallowable purpose rule applying. As I explained in BlackRock at 150, we're going to come back to that, it can't have been Parliament's intention that the unallowable purpose rule be engaged as an inevitable consequence of taking out a loan, or indeed charging interest on it at a commercial rate, subject only to consideration of whether the value of the tax benefits is sufficient to make it a main purpose. The mere fact that a group organises its affairs in a manner that makes use of brought forward non-trading deficits, and that it expects to obtain relief for interest at the expense of loan relationships, which is precisely what the Loan Relationship Code provides for, and precisely by analogy in our case what Article 12.1 provides for, in each case as the legislation contemplates, cannot be enough to engage the unallowable purpose rule. The comments of Mr. Justice Cross reflect a similar point in a different context. The tax consequences he was describing for a dealer were specifically contemplated by the legislation. And sorry to bang the drum, but that's exactly what we have in this case, in Article 12.1. Well, my friend shakes his head, but that is the position. That is what Article 12.1 is there to do. Can we then go back, please, to BlackRock? Previous tab.
Just to, for my note, the paragraphs you're relying on particularly are 85 to 87?
84 to 86. 84 to 86 and 80, and my learned friend has shown you 87 as well. But I rely on 84 to 86 particularly. And I also rely upon what I'm about to show you, my lady said in BlackRock, previous tab, page 604 of the bundle. Paragraph 150, just above letter E. Second sentence. The unallowable purpose rule forms part of a code contained in Part 5 of the Corporation Taxes Act 2009, which governs the treatment of loan relationships for corporation tax purposes, and which, among other things, specifically contemplates tax relief for interest and other expenses of raising debt. The corporation tax relief available is obviously a valuable relief. It's unrealistic to suppose that it would not form part of ordinary decision-making processes about methods of funding a company, just as it's unrealistic in this case to expect BLM to put out of its mind its ordinary entitlement to be taxed in its state of residence under Article 12.1. Indeed, you say, it might well be wrong for directors to ignore that consideration in deciding what is in the best interest of the company concerned. And that reflects what my Lord Justice Snowden put to my learned friend yesterday. It would be very odd if Burlington, in this case, somehow shut its eyes in some Nelsonian way. What treaty benefit? Of course they've got to take into account the treaty benefit. That's not contrary to the purpose of Article 12 at all. Then my lady continues, I agree with Mr. Prosser's submission that it can't have been Parliament's intention that the inevitable consequence of taking out a loan should engage the unallowable purpose rule, subject only to consideration of whether the value of the tax relief is sufficient to make it a main purpose. Something more is needed. And then the following paragraph as well. So all of those passages, and there's one other passage I want to come to in a moment, but all of those passages demonstrate that just because a tax position, which has been expressly provided for in legislation, there in the Unallowable Purpose Code, here in Article 12.1, is a feature of a transaction or a relevant factor in a decision to buy or sell an asset, or is a relevant factor in the pricing of the asset, it does not follow that obtaining the tax advantage or the tax treatment will be a main purpose of the party in question. And whether it is or not is a question of fact for the First Tier Tribunal. And there's a simple way of testing all of this. Could I ask you to just turn forward to paragraph 162? where my lady says, as Lord Justice Nugee suggested in argument, a simple starting point in ascertaining a person's purpose for doing something is to consider why they did it. While this won't cover all the nuances, in particular the potential distinction between purpose and motive discussed in the McKinley case, it's a sensible starting point. If you ask that question in this case, why did you buy this asset? The answer wouldn't be, we bought it to take advantage of our tax treaty position. The answer would be, as the FTT held, we bought it to make a profit, as we just had done on the previous 442 Libby debt claims, on the difference between the cash flows we expected to receive and what we were paying for it.
Would the answer to that question be different if you asked it from Sickle's perspective?
Well, in my respectful submission, even if Sickle had known of Burlington's Irish residence at the time that the commercial deal was done, as it did not, that would still not be sufficient to engage Article 12.5, because the something more that is required is typically going to be the seller retaining an indirect economic interest in the asset that's being sold. Now, I can see that that might have been a more problematic case for me on the facts, or for my client on the facts, but that's not the position that we are facing.
Well, to put it in a different way, it might be said, this doesn't mean that it amounts to saying that 12.5 applies, but it might be said that in some senses Sickle sold because of its withholding tax problem. In fact, I think there's some findings to that effect.
Yes.
As compared, at least, to some buyers in the market.
Yes.
So
but I have to say,
answering Lord Justice, if Sickle was answering Lord Justice Nugee's question,
well, but you still have to take into account the market.
Yeah.
So if the answer to my lady's question was that Sickle would be caught by Article 12.5,
I'm not saying that.
No. If that was the answer, then again contemplate the effect on the market. Sickle would then say, we're not going to sell to Burlington. We're going to sell to the UK pension fund, or the UK corporate with losses to offset, or to somebody in a treaty jurisdiction that has a full exemption from withholding tax without an Article 12.5 carve out.
And the reason why Sickle sold was to get a better value for the asset that it had.
Because it was the liquidator doing its job.
Well, they could have held on to it, and then they would have been paid in the ordinary way. That wouldn't have been the best outcome for them, but it wouldn't have been them failing to do their job. This wasn't, actually strange enough, this wasn't an asset they had to turn into cash. This was a cash generating asset. But the reason that they sold was to get a better price, was to get more money from the asset than simply retaining.
Than they thought they might, yes. But
because they knew that there was somebody out there that will pay me more than I can get from this asset for myself.
On the assumption that the Supreme Court didn't overrule the Court of Appeal in the withholding tax litigation and find that there was that post-administration interest was yearly interest or wasn't yearly interest and therefore subject to withholding tax.
Well,
the Sickle could have taken the view, let's hold on to this asset and wait and see what the Supreme Court decide. In the end,
they could have come. They decided they didn't want to take that risk.
Yeah, or and as I showed you in the passage earlier, and I don't want to island top. There were a range of reasons why Sickle might have been keen to get rid of the asset. Might have had what Miss Gibbons called seller's fatigue. But what there wasn't was a finding by the FTT, which my learned friend kept on saying there was, that the only basis why the buyers wanted to do this transaction was what he called below, but has now shied away from saying, withholding tax arbitrage. Can I then turn, unless there's any...
I mean, that's the seller. Sorry, that's the sellers.
Yeah, that's the seller's perspective. And the reason I'm focusing on that is my lady asked me about the seller's perspective.
Yeah.
Can I just deal with my learned friend's submissions on why this court shouldn't follow Mr. Justice Cross in Kleinwalk Benson? Of course, that's a first instance decision, although its reasoning has effectively been endorsed in the passages I've just shown you. One of the things he said was that the reasoning of Mr. Justice Cross on the main purpose test was obiter. In my respectful submission, it wasn't. Could I just hand up, I've given this to my friend this morning, a well-known tax case called Youngson and the Parole Board. Judgment of Mr. Justice, I beg your pardon, Lord Justice, as he then was legate, which I think is still the leading authority on when something is obiter or not. If you could turn, please, to page... Sorry.
Sorry, a bit of a private joke going on here. I think it's one of them. I think this,
Did you give another one?
No. I think there are a number.
I don't think I did either, but there are several.
Okay, all right. Well, it's one of the leading authorities.
My lady and I have been round this track before. I feel.
All right. Well, then what I'm about to say is entirely familiar. Can I just ask?
Well, no, that assumes I've got any retention.
Okay.
I did a few.
I'm glad I'm not the only one. If you turn, please, to page 412 of the Queen's Bench report. Did you just read from just below letter A, starting with in particular, to the foot of paragraph 49 at letter G? So I don't accept that what Mr. Justice Cross said in the part of the reasoning on which I rely was obiter. Second, my learned friend said that the legislative code in the case at issue in Kleinwort Benton was different. Well, it was different. It was different as each legislative code has its own features. That code had one feature, the unallowable purpose test has another feature, and this test has another feature, but they're all main purpose tests. And our case, like the unallowable purpose cases, form part of a code where Parliament, or in this case, the contracting treaty parties, have expressly decided to confer a tax treatment stroke benefit in certain circumstances. So I don't accept that somehow what Mr. Justice Cross said in Cross is meaningfully distinguishable from the present case. Lastly, my learned friends suggested that Mr. Justice Cross's reasoning involved an erroneous non sequitur, because in the trader example he gave, the profit that the trader was obtaining was, as my learned friend puts it, in no way dependent on obtaining a tax benefit. But that's wrong. For the reasons that my lady put to my learned friend yesterday, depending on the tax rate and the deductibility, the profit may well turn significantly to depend upon the tax position. And I also
well, in fact, I think those were the deals, the sorts of deals being done that Mr. Justice Cross was commenting on. Yeah. I think this is what used to be called bond washing.
Yes. Yes. Long since gone.
I believe so.
But anyway, the only other point I wanted to make in response to Mr. Brimsby-Stockham's assertion that what Mr. Justice Cross said was wrong is that so far as I I've been able to find none of the subsequent case law, including my lady's judgment in Quickfit, has suggested that what Mr. Justice Cross said in Final Benson was wrong. The next case I need to deal with is Fisher. And our simple point in Fisher is that it simply can't apply to the present context. And just to remind the court, and I'm going to take you to some passages in a minute, but Fisher is at Fisher Court of Appeal is at tab 21 of the authorities bundle. So just to remind the court, the question in that case was whether, if the individual taxpayers who were family members who had built up a betting business, if they fell within the transfer of assets abroad legislation on the basis they were to be regarded as transferors of the betting business. That was the first big if. Then the motive defence applied. Those are the questions. And for the motive defence to apply, they needed to show that the transfer of the business to Gibraltar was A, for a bona fide commercial reason, and B, that there was no main purpose of avoiding UK tax in that transfer. And UK tax was found to include betting duty. Critically, the FTT found on all the facts that they did have that main purpose. The Upper Tribunal accepted that there had been avoidance of UK betting duty, but disagreed with the FTT's evaluative conclusion that that avoidance had been a main purpose, its reasoning being that the taxpayers had been forced to restructure their business by transferring it to Gibraltar so as to be in the same tax efficient position as their betting business competitors, thereby, in the language of the judgment, saving the business. And so the Upper Tribunal reasoned that can't have been the main purpose. And at paragraph 91, page 470, Lord Justice Newey held that the Upper Tribunal hadn't been entitled to interfere with the FTT's finding of fact because, and this is the point that my learned friend relies upon so much, the avoidance of betting duty and saving the business were inseparable. That's what was said. And the learned friend says you can just read that across to this case. And there are three reasons why you can't read it across in ascending order of importance. The first reason is that, unlike in this case, Fisher was a case in which the Upper Tribunal had interfered with the FTT's evaluative finding of fact on the taxpayer's subjective state of mind. Secondly, Fisher concerned a domestic anti-avoidance provision under the Domestic Transfer of Assets Abroad Code, where the First Tier Tribunal had held and the Upper Tribunal had accepted that there had been avoidance of UK betting duty. So the starting point, unlike in this case, was that UK tax was prima facie payable on the transfer unless the motive defence applied, and that motive defence only applied if there was no main purpose. In other words, critically, Fisher did not concern a bilateral treaty provision where there is no prima facie starting point that a Republic of Ireland resident will be taxable in the UK on UK source interest. On the contrary, the position, as I emphasised at the beginning, is precisely the opposite. The starting point is that BLM was entitled to be taxed in Ireland.
Yes, just to be clear, the transfer of assets abroad provisions, if they applied, would have essentially meant that post-transfer the family stayed within the charge to income tax.
Yes.
So the avoidance of betting duty was a sort of...
it was a collateral...
was a hook,
was a hook.
if you like. But the consequence of the transfer of assets abroad provision...
Yes, my lady's right to make that distinction. Yes. That's right. Finally, I submit, our facts are fundamentally different from those analysed in Fisher. So in that case, the Court of Appeal said there was an inextricable link between the taxpayers' purpose of saving their business and the very transaction that they undertook to achieve that, namely to transfer the betting business to Gibraltar for the very purpose of avoiding UK gaming duty. So going back to Lord Justice Newg's question, that you referred to, my lady, in BlackRock, why did they do it? They did it, they moved the business to avoid UK gaming duty. By contrast, in our case, Burlington did not take any step to avoid UK tax when it purchased the SARD claim, any more than it had taken such a step in any of its previous 442 Libby debt claim acquisitions. BLM was and always had been a Republic of Ireland resident entitled to the treatment under Article 12.1 and simply knew or expected that it would be taxable on that basis. So for all those reasons, the Upper Tribunal was completely correct in dismissing Mr. Brinsmead-Stockham's reliance on Fisher as it did at paragraph 81 and 82. If we could just look at that. That's core bundle, page 108. If I could just invite the court to read paragraphs 81 and 82. And I do, with respect, echo the sentence that says, in our view, HMRC's reliance on Fisher demonstrates the fallacy of their case. They are starting from the premise that if UK withholding tax is being avoided, that is sufficient to constitute an abuse. And although Mr. Brinsmead-Stockham at times sought to distance himself from that starting point, that's exactly what his case entails. And so for all those reasons, in my respectful submission, the core complaint advanced under ground 2 is flawed and should be rejected. And that's all I want to say on ground 2, unless the court has any questions. Can I then finally deal with ground 3, and I'll be done well before 4 o'clock, probably by 3:30. Ground 3 criticises aspects of the FTT's reasoning, in particular at paragraphs 179 to 181, which, as I'll show you in a minute, is at page 200 of the core bundle. And I'm going to come to the criticisms in turn shortly. But before I do so, I have 2 overarching points. First of all, unless my learned friend can persuade you that his core case is right under grounds 1 and 2, i.e. how Article 12 should be interpreted and how it should be applied to the facts of this case, his supplemental complaints about aspects of the FTT's reasoning do not entail a conclusion that the revenue's appeal has to succeed. Because if you reject his core case, then even if there are aspects of the FTT's reasoning with which you disagree, and I'm going to show you why you shouldn't, the answer would still be that Article 12.5 did not apply in this case. So they are not, well, they would not be material errors of law. Or put another way, even if they were material errors of law sufficient to vitiate the decision, and they certainly aren't, and you were invited to remake the decision under your power to do so, you'd still be coming to the same conclusion. So however you get to the end result would be the same. My second point, which is in fact related to my first, is that in our submission, the First Tier Tribunal's essential reasoning on the core issue is to be found in paragraphs 172 to 178. And although under the rubric of question 2 concerning sickle, in 183 to 185. The passages upon which Milena Friend fixes in ground 3, namely 179 to 181, are, as the Upper Tribunal well appreciated, just ways of testing the logic of HMRC's case. They don't independently need to be upheld in order for the core reasoning to be approved. As I say, that sounds all rather defensive. I'm going to show you why there's nothing wrong with those reasons. I'm just, as a preface to what I'm going to say, explaining why even if the complaints were justified, which they're not, they wouldn't lead to a different result. So with that in mind, can we look at the complaints that are made in Milena Friend's skeleton, which is what he's relying upon fairly. If you could start with Milena Friend's skeleton in this appeal at paragraph 63. That's at page 44 of the core bundle.
Sorry, the paragraphs that you're focusing on, I think you said 179 to 181.
No, I'm saying that the core reasoning of the FTT.
No, what the errors are alleged to be in. I wrote
what Mr. Brimsmead Stockham is attacking in ground 3 is FTT 179 to 181.
Okay, although I think it may go.
Oh, sorry. Okay, 177 to 181. I don't want to try and curtail the scope of the complaint.
Well, I asked only because you say you're placing reliance on paragraphs up to 178.
Yes, I do. I do say that I have to accept. Frankly, you could stop at 176 and the result would still be the same. 177 and 178 is.
Well, I think that's what the Upper Tribunal said.
Yes, it did, and sometimes it's difficult to identify the core of the core. If there has to be a core of the core at the centre of the Venn diagram, it's 174 to 176. On one view, 177 to 178 is part of testing the logic of HMRC's case, but I say is completely correct. You then get to the outer penumbra of the reasoning at 179 to 181. And again, sorry, I'm not being, all of that is right. I'm just trying to see where the core lies. Can we look at Milena Friend's skeleton argument in this appeal at paragraph 63, where he sets out, or it starts at 62. So in 62, he just sets out 177 to 179 of the FTT. And he says at 63, these passages demonstrate that the FTT fundamentally misunderstood both HMRC's case and the meaning and effect of Article 12.5. In particular, HMRC's case that Article 12.5 applies here is not dependent on the specific price that BLM paid for the SARD claim or the specific amount of profit realised by BLM from the transaction. So again, going back to the consequence question, where is the line drawn if it's not based upon the specific price or the specific profit? How do you know how big a profit has to be dependent upon the withholding tax differential in order for HMRC's case to be made good? But anyway, before I get to the detail, it is a little unfair for the revenue to criticise the FTT for misunderstanding its case, given how its case was put in the FTT. Can I show you the FTT skeleton of the revenue? Our supplementary unagreed bundle. Tab 3, page 50. It starts actually at page 49 under the heading Application of Article 12.5 to the Facts. And then at paragraph 43, as for Sickle, at subparagraph 3, assigning the SARD claim to BLM allowed Sickle to obtain a sum in respect of the SARD claim interest that was greater than that which it would have received if it had retained the SARD claim and received the SARD claim interest subject to withholding tax. Footnote 23. This is made clear by a comparison of the price received by Sickle for the SARD claim, and it gives the number, with the amount of the SARD claim interest that Sickle would have received following the deduction. Same figures as now appear in Milner Friend's appendix to his skeleton argument. And then that's Sickle, but for BLM the argument is the same. See paragraph 44. As for BLM, it was in the inverse position to that of Sickle, and so was able to attempt to generate significant profits by acquiring the SARD claim from Sickle at a significant discount and seeking to avail itself of Article 12.1 in circumstances where Sickle was not able to rely on a similar provision. So it's a bit difficult for HMRC now to say, well, the FTT fundamentally misunderstood their case because it had nothing to do with a specific price, when that's exactly how they put their case below. In any event, the correct answer to the criticism about the FTT's reasoning in paragraph 179, when they tested the logic of HMRC's case on various hypothetical other prices, is to be found in the Upper Tribunal decision at paragraph 91 to 93. At 90 to 93. So if you turn to page 109 of the core bundle, maybe you can start at paragraph 89. Paragraph 89 records the complaint made below about the FTT's reasoning in paragraph 179. And then then paragraph 90 records, HMRC say they would have challenged such a case as much as the actual transaction. In their view, the only difference would have been the amounts of income and profits realised by BLM and Sickle. In the assumed case, BLM would simply have obtained all of the UK withholding tax saving. In our view, well, may you just read paragraphs 91 to 93, with which we respectfully agree. So faced with that reasoning, the learned friend's skeleton in this court deals with the point at paragraph 65. Could we look to see what he says in this court in paragraph 65? That's core bundle page 44. He says, the Upper Tribunal's analysis of the First Tier Tribunal's reasoning at 179 provides no answer to HMRC's criticism that both transactions, the actual and assumed, would fall within the scope of Article 12.5 on the basis that it was the main purpose of BLM to take advantage of Article 12.1 by the assignment. But that paragraph, again, demonstrates the problem at the heart of the revenue's case. Despite the cornerstone of their case being said to be the economics of the transaction, what they're really saying is that whatever the price paid by BLM, whether it was 92 or 80 or some other figure, they would still be arguing that Article 12.5 applied. So that just reveals the fact that their case must be that whenever a buyer of an interest-bearing debt claim is subject to tax in its state of residence in accordance with the usual rule under Article 12.1, then unless it shuts its mind to that tax treatment when agreeing to purchase the debt claim, which it's obviously not going to do as a responsible economic investment company, it will, in a circular way, automatically disentitle itself from having the benefit in the first place. That can't be right. So that deals with HMRC's criticisms of the FTT at 179. The next two sets of criticisms are aimed at what the FTT said about the relevance of the previous 442 debt claims that that BLM had acquired in the Libby debt market. So if we can just remind ourselves of what the passages are of the FTT's judgment that have been criticised here. If you turn to page 200 of the core bundle and just reread paragraphs 180 and 181. So Millennium Friend's criticism of these paragraphs essentially amounts to saying that the previous 442 Libby debt claims acquired by BLM, where the revenue didn't contend that Article 12.5 applied, were irrelevant, and that the only conclusion open to the FTT on the evidence, on an Edwards and Bairstow basis, is that the SARD claim was fundamentally different. That's how he puts his case in the skeleton. That repeats the point that he made below to the Upper Tribunal. And again, we respectfully endorse the answer to the Upper Tribunal given by the Upper Tribunal in its judgment. See, in particular, paragraphs 97 to 101. If I could ask the court to read at page 110 and 111 the Upper Tribunal's judgment at paragraphs 97 to 101. The final point to deal with is what Millennium Friend says in his skeleton at paragraph 71 to 72, where he says the Upper Tribunal wrongly endorsed the FTT's conclusion at FTT 181. He says the FTT...
Sorry, can you just give me the paragraph?
Yes, sorry. Page 46, core bundle.
Yeah.
Millennium Friend's skeleton argument, paragraph 71 to 72. This is a straight Edwards and Bairstow challenge.
For which there isn't permission.
Well, to be fair to the revenue, I've checked this.
Yeah.
Their freestanding, unparticularised tailpiece Edwards and Bairstow ground of appeal was refused permission.
Yeah.
This language appeared in a ground of appeal that was before you, for which you did grant permission. So I can't take that point, much as I'd like to.
Meaning neither can we.
Neither can we. But it's a hopeless point, and it's a hopeless point. A, because of the very high Edwards and Bairstow threshold, and B, because what Millennium Friend has to say is that the only conclusion reasonably open to the FTT was that the SARD claim was in some way fundamentally different from all the previous 442 claims that form the factual background. And what he says is that's in particular due to the fact that it was the only Libby debt claim purchased after a decision of the UK courts had been handed down to the effect that the interest on such claims was subject to withholding tax. But the problem with that is that that was not a fair characterisation of the position. As the tribunal recorded, Burlington had acquired many claims in the Libby debt market, including many claims in what was called the lacquer auction, which started in April 2016, and which included buying debt claims from sellers resident in territories that did not have a double tax treaty with the UK at all, or which didn't grant full treaty relief on the interest. And you can see that, A, from the judgment, and B, just to show you the detail. If you can go into Millennium Friend's unagreed supplementary bundle, not ours, Millennium Friend's, you turn to tab 25, appended at Schedule 7 to a letter from Simmons and Simmons in January 2020 to the revenue, there is as requested.
So I'm going to irritatingly ask you for the reference again. I was
Yeah,
writing.
if you could
Page
go
256.
to tab 25 of the revenues unagreed supplementary bundle. Starting, if you pick it up at page 272 of the PDF.
272.
272.
Oh,
It should be a spreadsheet that looks like that.
okay.
Yeah. I've lost all my tabs in this.
You need to drop
I don't
down.
have them.
Yeah, I've got the page. Okay.
This is a set of information provided to the revenue in answer as part of their inquiries. If you look at the top of the landscape page in the title, list of claims.
Sorry, I've lost the page number again. I was looking at tabs.
HMRC unagreed
can't get
supplementary
tabs open,
bundle,
so.
page 272.
Thank you.
Does the court have that? So if you just look between the tram lines at the top, list of claims where the seller or grantor was, at the time of the acquisition by Burlington, resident in a territory that didn't have a double taxation agreement with the UK, or was resident in a territory that had a double taxation agreement with the UK, which didn't grant full relief in respect of income tax withheld on interest. Then you can see in the columns type, they're mostly are lacquer claims. That's the Libby debt auction that's described in the FTT's decision. Then there's a date, and the significance of the date, as you can see, 16th of May, is that most of them, if not all of them, predate Mr. Justice Hilliard's decision in October of that year to the effect that post-administration interest was not yearly interest and therefore subject to withholding tax. So at the time of the purchase of these debt claims, there was no certainty at all.
Yes, but it was presumably known for quite a while that the revenue was pursuing that.
Precisely so,
which did not succeed initially before.
So at the time, they probably thought that withholding tax was a risk for them. That's, with respect, my lady's hit the nail on the head.
Mm.
Because Learned Friends case, well, the Sard claim is unique because it's the first time that there's a decision of the UK court saying that withholding tax is an issue for people in Sickles' position. But that technically that is correct. But it's much more nuanced than that, for the reason that my lady's just identified.
When did you say that the High Court decision was?
October 2016. So all these claims bought from Cayman or other jurisdictions, and you can see the jurisdiction in the column owner jurisdiction. Many of them are Cayman. All predate the Robert Hilliard, the Mr. Justice Hilliard judgment. And likewise, yes, it's true that by the time of the Sard claim purchase, we had the Court of Appeal's decision reversing Mr. Justice Hilliard, but as Lord Justice Zacaroli sought to discover and was correctly told the answer to, there was still an outstanding application for permission to appeal to the Supreme Court. So that's one reason why the Sard claim was not unique, and the FTT wasn't bound on an Edwards and Bairstow basis to treat it as such. And then finally, as I said before, the evidence of Miss Gibbons was not that the Sard claim was bought because of the impact of the Court of Appeal judgment, and there's no finding of fact to that effect made by the FTT. If we can just go back to the FTT's judgment, paragraph 160. Now, paragraphs 158 to 160 record the parties' submissions. Just want to make that clear. But if you look at 160 sub 3 and 4, this is me recording, or me being my submissions being recorded as to what Miss Gibbons had said. 3, Miss Gibbons had also testified that there were very few Libby claims in the market at the time when the appellant purchased the Sard claim, and this was because most of the holders of Libby claims who had wished to sell their claim had disposed of their claims in the lacquer auction, and the announcement by the Libby administrators in December 2017 to the effect that a scheme of arrangement which would resolve most of the uncertainties in relation to the quantum and discharge of the Libby claims was imminent meant that most of the remaining creditors were happy to hold on to their claims, unlike Sard. Thus, the fact that the Sard claim was the last of the Libby claims which had been purchased by the appellant, and only the Libby claim which had been purchased by the appellant following the date of the Court of Appeal decision in the withholding tax litigation, was entirely attributable to the state of the market in Libby claims at the time when the Sard claim was purchased, and had nothing to do with the fact that the interest payable under the Sard claim was going to be subject to UK withholding tax. And then what the FTT made of that can be seen in paragraph 181, which we looked at before. Page 200. It will be apparent from the conclusion we have reached in relation to this question that we don't regard any of the points of distinction between the starred claim and the other claims in the Libya administration, which are described in the exchange recorded in paragraphs 158 to 161 above, as having any bearing on the issue which we need to resolve in these proceedings. So, difficult for the learned friend to say that's an essential part of their reasoning when they've said the opposite. But in any event, as Mr. Grudzinski pointed out in the paragraph I've just shown you, there were sound reasons why the SARD claim was acquired when it was and in the manner it was, and we can see nothing in those circumstances to suggest that the SARD claim should be regarded as exceptional in any way which is relevant to the matter at issue in these proceedings. For the learned friend to say that's an Edwards and Bairstow impermissible finding is hopeless. Unless I can assist the court further, those are our submissions.
No, good, thank you very much. Right, I think that's undoubtedly a convenient moment just to have 5 minutes for the transcript writer, if that's okay. Take 5 minutes and then we'll resume.
Might I ask, when is the court planning to sit until?
Well, the trouble is,
to what extent do I have?
I'm not sure I want you to expand the submissions to fill the available time.
I promise I won't do that.
Well, I think we should aim for 4:15.
Okay, I'm grateful.
I mean, that gives you.
I will try and.
That gives you 45 minutes.
I'll try and
I think
finish
it's.
before then if I can. Yeah, absolutely. I'm grateful. Done up at the back.
I can't see.
Yeah, I think they're just loose. So like a scruffy kid at school. Well, which was me, so. Seems fair.
So much for having lots of spare time.
Yeah. Ample time.
Ample time.
Yes.
My lord, I'm afraid it's in the nature of replies that one tends to just deal with the points in the order that my learned friend did. And I propose to follow that convention, save for one point. And there was one point that came out during a number of exchanges with the court that in my submission is of absolutely fundamental importance to this case. And in my submission, it represents a fundamental error in my learned friend's analysis of the position. So I'm going to address that first. If I only make this one point in reply, I would like the court to have understood that I've made this submission. I put it at that height. So there was.
I'll write it in capitals.
I'm very good, and possibly a particular font. I don't know. That might be important as well. But there has been throughout my learned friend's submissions a suggestion that in this case, on the facts of this case, Article 12.1 does not provide a benefit to which Article 12.5 could potentially apply. My learned friend went so far as to say, I'm going to refer to it as a treatment rather than a benefit. And that was said to be because, well, it's simply an incidence of being a tax resident in Ireland. Now, my submission, that is a fundamental error in analysis. To take things one stage at a time, Article 12.1, Article 12 itself obviously deals with interest. Article 12.1 provides an exemption from withholding tax, in effect, in the state of the source of the interest. In this case, that's the UK. It could equally, in a different case, be an Ireland. But it's an exemption from tax in the state of source. My submission, that is plainly, and without any shadow of a doubt, a tax benefit that you would not otherwise get without the treaty, specifically here without Article 12.
Doesn't that assume you are taxed in the state of source? To describe it as an exemption assumes...
Certainly on the facts of this case, it would have been taxed in the UK domestically. But my submission is that on the facts of this case, it undoubtedly provides an exemption from UK tax. Article 12.1 is expressly subject to Article 12.5. And just to make that absolutely good, if one looks back at the terms of Article 12 as a whole, perhaps we don't need to go there, I can just read it out. It's page 46 of the authorities. In effect, the provisions of this article shall not apply if, then the test in Article 12.5. Now, in my submission, one cannot assume the existence of Article 12.1 separately to the existence of Article 12.5. They do not exist as separate entities. They are all part of Article 12. And the whole of Article 12 represents the deal between the two contracting states as to how interest is going to be treated as between them. In my submission, it follows from all of that that you only get the benefit of Article 12.1 if Article 12.5 does not apply. Article 12.5 operates to delineate and to define the parameters of the benefit provided by Article 12.1. And you see, in my submission, plainly from the words, Article 12.5 applies. It's a main purpose of the party here to the assignment of obtaining the benefit of Article 12.1. So my submission to suggest...
I understand the submission that Article 12.5 says that Article 12.1 shall not apply in certain circumstances. So then it's as if it just wasn't written.
The whole article doesn't apply. The provisions of this article should not apply. Yeah. So the whole thing goes away if 12.5 applies.
Right. And
you're left then on the domestic tax position, subject to the double tax relief article. So,
well, you say you're left with the domestic tax position when? Before the assignment or after the assignment?
Well, if 12.5 applies to the assignment.
Suppose we have no Article 12. If Article 12 doesn't apply, what's the position you're left with?
That's a difficult question to answer because Article 12 in this treaty will only apply in a circumstance where you have an interest payment between the UK and Ireland. So, in the absence of the assignment, there wouldn't have been such a payment. So, Article 12 wouldn't be engaged at all. There would have been a payment between the UK and Cayman.
Right.
And then we'd have been in the Cayman Treaty, where there isn't an equivalent provision dealing with interest. So, you'd just be left with UK domestic tax. We only get into Article 12 because of the assignment and because there is specifically
there is
payment of interest.
There is an assignment, and interest is paid from the UK to Ireland.
Indeed, my lord, yes.
So the question is, how is that taxed, or where is it taxed? So you start with the proposition, don't you, that it's a payment from England to Ireland?
You do, my lord, yes.
Right.
But in my submission, you do have to start from the position that the domestic tax position in the UK would be that that payment would be subject to income tax. The question then is, does the treaty operate to mean that the UK can't tax it? And if 12.1 were to apply, that would be the result. But if 12.5 disapplies 12.1, that is not the result. And in my submission, you simply cannot proceed on the assumption that 12.1 applies in vacuo and say, well, you're an Irish resident, therefore you're not taxable on interest. That's not a full account of the position. As an Irish resident, you are not taxable on UK source interest only if you have not acquired that interest source with a main purpose of benefiting from Article 12.1. And in my submission, that really is fundamental to this case. The whole of Article 12 has to be read together. You can't, my learned friend can't just pick and choose and say, well, 12.1, we're not taxable. Because 12.1 is and is always subject to 12.5. So that was my first submission. I hope I've not garbled it or not made it clearly, but I really do want to convey that in the strongest terms. Moving then back to sort of the order that my learned friend went through his submissions. My learned friend said that for 12.5 to apply, the transaction must be contrary to the object and purpose of Article 12.1. Now, I accept that because I've always accepted, and HMRC have always accepted, that Article 12.5 is an anti-abuse provision. The point is that HMRC say that this transaction was contrary to the purpose of Article 12 as a whole. And I outlined the purpose in opening of my submission as to what the purpose of Article 12.5 is, that it operates where a person has a main purpose of being concerned with obtaining the benefit of Article 12.1 to switch off that benefit and to disincentivize transactions of that kind. It doesn't prevent them, but it economically disincentivizes them by turning off the exemption from withholding tax provided for in 12.1. And I go on to say in my submission that is a perfectly rational purpose for the UK and Ireland to have sought to achieve. And that's particularly so when one looks at the economic effect of this transaction, which I set out in the appendix to the skeleton argument. The result of this transaction is, in this case, because the payment would have been subject to UK withholding tax, is to prevent the UK from being able to recover any withholding tax at all, and to share that withholding tax out in between the participants to the transaction. Now you have my submission that the same would be true in a mirror
in contrast, the effect of the treaty applying, 12.1 applying, is that Ireland has its full domestic taxing rights and doesn't have to cede any of them.
No, that's right, my lady.
To
And it would
the
be able
UK. That's what 12.1 does,
but it would
when it applies.
We don't have any evidence as to the Irish tax position.
I'm not saying we do.
No.
I'm saying what the treaty
Indeed,
does.
my lady's absolutely right, of course. But my submission would be, and we don't have any evidence, the Upper Tribunal did set out a summary of the Irish tax position, but just from first principles, on the transaction, BLM would have made a profit of 8 out of the 100. It would only be that 8 that would be subject to tax in Ireland at most.
We don't know.
Well, we don't know.
We don't even know that.
We don't even know that, my lady, no. But my submission is that from both the UK and Ireland's perspective, the ability to tax withholding tax up front at 20% is a very different thing to taxing the profits of a particular transaction. And so whether one's looking at the position of the Irish revenue or HMRC, what they are both doing under Article 12.1 is foregoing that ability to tax withholding tax, which operates prior to, in effect, the computation of the profit in the other state, the state of residence. So in my submission, it's a perfectly rational end for both the UK and Ireland to want to achieve, to be able to protect their tax receipts from transactions of this nature.
Can you just put into a sentence or two how it is, you say, that this transaction is contrary to the object and purpose of 12.1 if the object and purpose of 12.1 is to distribute taxing rights as between the UK and Ireland?
Well, it has to be because if one enters into a transaction with the main purpose of benefiting from 12.1, then the parties have provided, in my submission.
But that repeats the words of the, well, it paraphrases the words of 12.5. I'm adding in what you accept should be added in, which is that it must be contrary to the
purpose of Article
object
12.
and purpose of Article 12.
Article 12, it must be Article 12 as a whole.
Right.
One must be able to look at 12.5 to identify what the object and purpose of Article 12 is. So the purpose is to say, as the provision provides, that the state of residence of the beneficial owner has taxing rights subject to Article 12.5. And in my submission, the parties very clearly set out that if you enter into a transaction with the main purpose of obtaining that benefit, and it is a benefit, then you don't get the benefit.
So adding the words must be contrary to the object and purpose of Article 12 doesn't actually add anything at all.
Well, we have a specific anti-abuse provision in Article 12.5. If you fall within the terms of it, then you are abusing Article 12. That's really my submission, yes. But one has to look at the purposes of Article 12 as a whole. One can't, in exactly the same way that one can't look at Article 12.1 in vacuo, one can't look at the purposes of Article 12.1 on its own. It has to be read in its whole context, which obviously includes Article 12.5. So my submission, perfectly rational purpose for both contracting states to pursue. My learned friend then spent quite a bit of time dealing with the First Tier Tribunals where it addressed what it identified as question 2, concerning whether BLM had a purpose of providing any benefit to Sickle. As I set out in the skeleton argument for this court, that has never been HMRC's case. HMRC's case has always been, in respect of BLM, that it had a sole purpose of generating profit by benefiting from Article 12.1, and that fell within the terms of Article 12.5. The relevance, though, and my learned friend says, well, they're pointing to Sickle's position, and for some reason that's said to undermine HMRC's case. In my submission, not so at all. The relevance of Sickle's position in this case is that BLM expressly knew Sickle's position. That meant it knew that withholding tax was the sole basis for this transaction. In my submission, that is clearly a relevant consideration because it goes to BLM's subjective main purpose.
Can you just repeat that sentence? You said BLM knew that. Sorry, repeat.
BLM knew Sickle's withholding tax position.
Yeah.
In my submission, that is relevant because it means it goes to the fact that BLM knew withholding tax was the sole basis for this transaction.
Well,
So the
maybe
withholding
the
tax
sole basis.
differential.
Yeah,
Okay, that's the
that's what I was going to pick you up on. Yeah.
sole basis from Sickle's point of view. But you're saying
No, my lady. The sole basis on which BLM was able, on any view, to enter this transaction was by reference to obtaining the benefit of Article 12.1. And we have the First Tier Tribunal findings of fact that from BLM's perspective, in this appeal we are only concerned with BLM's perspective. We're not pursuing the position in respect of Sickle's purposes. But we have the findings of fact in 1641 and 1642 that from BLM's perspective, the SARD claim was worth 80 to Sickle, approximately, 100 to it, approximately, and that the difference was attributable to the withholding tax treatments, the different withholding tax treatments. Now, in my submission, that is equivalent to a finding that the economic basis for the transaction is solely attributable to the withholding tax, because that is what gives the difference in value, and nothing else. None of the other two risks. We saw that the tribunal had held that the liquidation lacuna was regarded as irrelevant by BLM, and you had my submission noting there's no finding of fact at all as to how the late termination risk was priced, although BLM was aware that it applied equally to both parties. So my submission, the only difference of value, the only basis on which BLM could possibly be said to have entered into the transaction was by reference to the different withholding tax treatment. My learned friend then turned to the consequences of HMRC's case and said, well, it must, in effect, Article 12.5 must always apply whenever there's a difference of withholding tax treatment between two counterparties. My submission, that's not right, HMRC maintain and have always maintained that there must be a subjective main purpose of obtaining the benefit of Article 12.1, and of course that will turn on the facts. Now, I can only apologise that I'm not able to identify in a pithy sentence what main purpose means.
Can I just
Of course, my lady.
re-clarify, and I think you did deal with this in opening.
Of course, my lady.
I think you said either that you, by that, would capture either doing a transaction at all or doing a transaction at a price.
It could, well, I couldn't, again, it's difficult, there are infinite variety of circumstances. I don't think I can rule out that it could potentially impact on setting a price. So it may apply by reference to the price agreed. Here, though, my submissions don't rely at all on the price. I put my submission solely on the basis that the transaction would not have occurred at all absent the withholding tax differential. Now, of course, it will turn on the facts, and if 12.5 does apply, then the effect would be to disapply the tax benefit in respect of any interest in the transaction, the benefit under 12.1. But of course, as I submitted in opening, any other commercial upside of the transaction would remain. So if and to the extent that one was trading on the basis of different recovery of principal, that would be unaffected. One would only be looking at the withholding tax position on the interest. I also submitted in opening, and I reiterate here, that it is not the purpose of Article 12.5 to seek to create a level playing field in the debt market. That's simply not its function at all. It's part of a tax treaty. And so the fact that the First Tier Tribunal and my learned friends seek to point to other participants in the market who may be able to buy at a different price, the answer to that is that doesn't matter. We are concerned only with applying Article 12, and in particular Article 12.5. And you have my submission that the purpose of that provision is, in effect, to protect the tax bases of the UK and Ireland. Returning then to the criticism that my learned friend makes of me that I can't articulate what main... Oh, sorry, my lord.
No, I suspect you're about to carry on. You may well be about to deal with the point I was going to put to you, so go on.
Well, I am not able to articulate in a sentence or even half a page what main means. I can possibly plead in my defence that we have many, many decisions of UK courts and tribunals trying to identify what main means, and no one's really come up with a pithy statement of it, in much the same way that it's very difficult to say what reasonable means. Of course it has a connotation of importance, we know that from travel document services. But in my submission, that is a criticism of policy, really, as to the use of main purpose tests. One may reasonably say that they're not effective, or they're not particularly determinative, and one may criticise a tax authority for using those. Now, I'm obviously not seeking to do that, but it is a criticism of policy. It's not a legal argument as to whether or not a main purpose test is satisfied in this case.
But you do accept that transactions where the differential tax treatment is an important factor in the setting of the price, or in the agreement of a price, could be called.
I do accept that, absolutely, yes. And I accept also there'll be difficult factual questions as to whether or not a main purpose is evidenced on the facts. But that's also true in the Unallowable Purposes Code for loan relationships, for example, and many other tax provisions.
Well, except that based on what I said, at least in Quickfit and BlackRock, it's not enough.
Well, my lady, if I could just seek to, I mean, we're in very different circumstances, of course, the domestic loan relationships
we are indeed.
And a treaty. One difference I might highlight is that underlying, if I may, my lady's reasoning in Quickfit is to say the deduction of interest as a cost in a transaction is so fundamental to the UK tax code, and has been for certainly longer than I can remember. That there must be something more than just that deduction in order to engage in anti-avoidance provision. But in the context of a treaty, where the two contracting states have sought to agree particular terms, in my submission, there's no particular reason to assume that either contracting state has given up its right to tax as the source state. there isn't that same sort of, you don't come to the question with the same assumption that, well, surely interest must be deductible. We all proceed on that basis. There's no such assumption here. We're simply saying the contracting states have entered into this deal. Article 12.1 will exempt a taxpayer from tax in the source state unless Article 12.5 applies.
Okay, but the analogy is that this all goes back to the difficulty of the dividing line, because the analogy is that if your case was right, Article 12.1 would not apply in very, very many situations. Wherever tax has been treated as an important element, or as having some importance.
Well, some importance. I mean, the test is it a main purpose?
Yeah.
That's the question. One can't just simply rewrite that to be of some importance. We know it has a connotation of importance. That finding was in the context, my lady will recall, of a submission that anything more than merely trivial was
Yes.
a main purpose. That's plainly a bad submission. So that phrasing of a connotation of importance doesn't seek to define the entire bounds of what constitutes a main purpose. It's a statement that's relevant to the construction of that phrase. But I don't think one can simply say it has a connotation of importance, therefore it's the main purpose. Tribunal would have to ask, was it a main purpose for the transaction? And answer it, well, the main purpose of the party entering into the transaction, and answer that on all the facts.
Well, entering into the transaction on the terms they were entered into.
Entering into that assignment, yeah.
That assignment, in
That
other words, on the
particular-
terms.
Yes.
So as soon as you start saying that you can look at how the terms were negotiated or arrived at, it becomes increasingly likely, doesn't it, that whatever your definition is, that something as significant as 20% withholding tax is likely to trigger 12.5.
But my lord, that does just go back again. That, in my submission, that's a policy criticism of main purpose tests. That's how main purpose tests operate.
Well,
One has to identify whether or
no,
not it was a main purpose.
Obviously you can make that point, but you can also say maybe that tells you something about what 12.5 means.
Well,
that's the fundamental point.
Well, I did also seek an opening. I'm not going to retread over those
No, I know.
steps to identify. There are a number of reasons why Article 12.5 wouldn't apply. So
You've made.
I'm not going to
those
remake that point, but
yeah.
I don't, as I say, I don't shy away from the fact that it will apply. It is intended to be an anti-abuse provision, and it is intended to have real substantive effect. So we shouldn't be assuming that the parties included it and just assumed it would never apply. We saw that they, in my submission, broadened it substantially in 1998. In my submission, the fact that it applies in a number of cases should not be a reason for holding that it doesn't apply in this case, particularly when here we are not dealing with a main purpose. My submission, which I'm rather banging the court over the head with to some extent, it's a sole purpose here. That goes on to my next point, which is there was a debate or some interaction with a learned friend about whether you construe main purpose in a narrow or broad sense. You have my submission that the approach and the meaning that concept has in UK tax law is the meaning that should be applied. But in my submission, when we turn to the facts of this case, it doesn't matter whether you construe it in a narrow or a broad sense. Because again, this is not a case where you're weighing commercial benefit against tax benefit. Here, there is nothing beyond the tax benefit in my submission. My learned friend then turned to Vietjet, and in particular looked to paragraph 107 and said, well, that's just determinative. The first sentence of paragraph 107 is determinative of, in effect, completely undermines my ground one. My submission, that is plainly not right. The court in that context is looking, and the entire debate is framed by reference to the argument that Vietjet were making, which was that simply by incorporating an entity in the UK, without more, there was, you fell within Article 11.7. In my submission, when you look at the actual reasoning of the court, which I said in opening, I take no issue with, the two reasons that are given are, number one, it's an anti-abuse provision, and in, as they say, in paragraph 113, as the Lordships say, here, there's no conceivable abuse. There was no possibility of a tax benefit at all because no interest was ever going to be paid, and the only result would be that a UK entity was taxable in the UK. So my submission, that is a million miles away from this case. You had nothing equivalent to the saving of UK withholding tax that results from the transaction in this case. And the second reason that the court gave was that FWC did not have the relevant purpose. It had a purpose of obtaining a status under a contract, and that plainly, and I would entirely endorse this reasoning, is not a purpose falling within Article 11.7 or 12.5. It must be, those provisions must be directed at obtaining a benefit under the treaty. And it's clear throughout the analysis that the entire focus of Vietjet's argument was to say you're seeking to obtain, your purpose is to seek to obtain a status under a contract. Well, that's not a treaty benefit at all. If I could turn briefly then to the OECD commentary, I want to make one brief point that actually my lady foreshadowed. It's page 848. This is the 2014 commentary. I'm going to make a very similar point in relation to the new commentary as well. But if I can put it very briefly, there is some introductory. So we're all, I accept we're all in the section improper use of the convention. We have some introductory matters, and then you get to paragraph 9. My submission, as my lady identified, paragraph 9 is concerned with general principles that apply in the absence of a specific anti-abuse provision. You can see that most clearly in the transition from paragraph 9.5, which my learned friend placed a great deal of reliance on, to paragraph 9.6. The potential application, so 9.6 and 849, the potential application of general anti-abuse provisions does not mean there is no need for the inclusion in tax conventions of specific provisions aimed at preventing particular forms of tax avoidance. What the commentary then goes on to do is to set out a series of examples of the kind of things that specific anti-abuse or anti-avoidance provisions might seek to counteract. So you actually have 5 examples if you flick through the pages, starting at page 851 with conduit company cases. Now I do rely on the fact that conduit company cases in the commentary are dealt with entirely separately from the provision that we are concerned with. My submission, that tells against my learned friend's submission that to the extent it is made, that Article 12.5 is limited to conduit company cases, because as we see, you have conduit companies as example 1.
Sorry, where are you looking?
Sorry.
8.5.
So it starts at 851, my lady, yes. So that's, these are a series of examples of specific situations and specific provisions. Number of possible ways of counteracting conduit company cases are given in that section. I don't propose that we read them now. But that runs all the way through to 21, provisions which are aimed at entities benefiting from preferential tax regimes. That's example 2. And I should say the fonts all align on this point in terms of level of examples. Number 3, provisions which are aimed at particular types of income. And then number 4, which is our provision, anti-abuse rules dealing with source of taxation of specific types of income. So our provision in my submission is dealt with very clearly in a separate section. One can't, and it's dealing with a specific anti-abuse provision. One can't simply read the general provisions which apply in the absence of such a specific provision to that specific provision. The specific anti-abuse provision has to be applied on its own terms, the terms that have been agreed between the contracting states. And in construing that, in my submission, it's absolutely right to have regard to that bit of the commentary. And that is the only bit of the commentary you have in submission in opening that deals with that point. One point I did want to pick up on was a point my lady made, which I didn't address. My lady rightly identified that that paragraph is deleted. Now, I think I said, well, that's because Article 29.9 comes in and you then have a principal purpose test. The one thing I did want to submit was to say the deletion of the commentary cannot affect the correct construction of Article 12.5.
Well, it's more that what I found interesting about that is it's the reason given for the delete, if I understand correctly, the reason given for the deletion is you've now got a general provision in the later commentary. But the commentary around that general provision is very much consistent with the general material you've just referred to, which you've just distinguished and say it doesn't apply, look at just 21.4. But that doesn't really quite work logically, because if those responsible for the commentary thought that they didn't need things like what's in 21.4 because there's a general provision, what they say about the general provision is
Well, I don't think you can just
informative.
read.
No,
You can't read it across.
well, I think you potentially can and should. When you look at we're told you can look at later commentary. We shouldn't be freezing ourselves in time in 2014 or 15, which of course by itself is well after 1998. If we look at the more recent commentary, the general comments in there, you could say indicate the sort of provision
Well, my lady,
at
I'm
which
not.
this is aimed, and that commentary relates to a general provision which was thought sufficient to replace essentially what's in 21.4.
Well, and that's in the context of many countries entering into the MLI and the multilateral instrument and adopting those provisions, and that incorporates the principal purpose test. Now, I have not sought to make submissions by reference to the provisions of Article 29.9. It is a different provision. My lady, if my lady is saying that those provisions are relevant and are potentially
No,
potential
I'm
importance,
not.
I should at least flag, my lady,
Yeah.
there is an example, and I must be clear, I'm not
Yeah.
seeking positively to rely on this, but my lady has identified it as a point. There is an example at page 898 of the 2017 commentary that deals with the principal purpose test.
Yeah.
And my submission would be, my submission is that the commentary on the principal purpose test, you can't read it across. It is a different provision. Clearly, it's related. Clearly, to some extent, the main purpose tests in 21.4 are an antecedent of the principal purpose test, but it is framed by reference to the purposes of the arrangements. It's where it's reasonable to suppose that it's a main purpose. It is a different provision.
Okay.
But if my lady is saying that the commentary on the principal purpose is potentially relevant, then example A on page 898 in my submission is not exactly this case. In my submission, it's very close. Now, I'm not going to say much more about that because I'm not making it as a positive submission. In effect, you've had a dividend announced. The right to the dividend is sold to an independent financial institution. So it's not a conduit type scenario. And there, the commentary is saying the PPT would apply because it would be a main purpose of the acquirer to obtain the benefit of the relevant exemption from withholding tax. So, if I can put it like this, I don't positively rely on that because in my submission, you should be looking at the commentary in 21.4.
Thank you.
But if you do go on to look at the principal purpose test and its commentary, then that is the clearest and most relevant example that's in the commentary. The next point I wanted to deal with was just a very quick point about the Upper Tribunal decision. The Upper Tribunal did quote quite a bit from the 2014 commentary. If I could ask you to turn up the core bundle, I'm very conscious of the time, are at 100. And this is just one. In paragraph 53 of our skeleton, I identify a series of criticisms of the Upper Tribunal. But you see in paragraph 48, the Upper Tribunal set out various passages from the OECD commentary, stopping at paragraph 9.5, which you have my submission. That's the general. That's the position. The general position. 49 then says the commentary then goes on to observe that where specific avoidance techniques have been identified or are especially problematic, it will often be useful to include provision directly addressing the concern. Bottom of that paragraph, the commentary then discusses a wide number of examples of possible solutions open to member countries to deal with particular cases. Among the examples set out paragraph 21.4 under the heading is a formal provision that is in all material respects the same as Article 12.5. Now, my submission, the Upper Tribunal has set out quite a lot of provisions which are, if at most, indirectly relevant. It has noted paragraph 21.4, but in my submission it hasn't noted that the submission I made, which is that 21.4 provides expressly for equating take advantage with obtain the benefit of. Sorry, take advantage of and obtain the benefit of. Just while we're on the subject of the commentaries, my lady, Malena Friend made a number of submissions in relation to that particular paragraph, paragraph 21.4. If I can just, I won't take the court to it, I've already shown you it, my lady. The paragraph, obviously I do place reliance on it. You have my submission. The text, whilst perhaps not full, is not incorrect. It's absolutely right to say that it will apply where it is a main purpose of one of the persons to obtain the benefit of the particular benefit, the particular treaty benefit. But in my submission, the importance of that commentary is that it does plainly equate taking advantage of with obtaining the benefit of. And secondly, there is nothing in that commentary anywhere to suggest that the provision is in any way limited to artificial steps or arrangements, as Malena Friend's respondent's notice seeks to suggest. My lady, I need to address then just the submission I made about the OECD commentary being a specific agreement between the UK and Ireland.
Yes.
I fully accept that's not a point that has been addressed in the case law. It's not a submission that's been made. My submission seems to me as a matter of principle to be right. But really, it probably doesn't take us much further, because it's absolutely clear from Fowler that the commentary is admissible. It's plainly also relevant that neither contracting state has entered an observation or a reservation. I mean, plainly, if Ireland had said, we don't think Article 12.5 means what is said in 21.4, that would obviously be relevant. So there are no reservations or observations that are relevant. The only relevance of there being an agreement between the parties, a subsequent agreement, would be that the materials fall within Article 31.3a, which require that that material shall be taken into account. So, except it's a new point, but in my submission, you are entitled to have regard to the commentary in any event. My learned friend took you to the new commentary. If I can make very briefly, in effect, the same submission that I made in relation to the old commentary. If I can break it down in this way, first point, there's absolutely nothing in this new commentary that's contrary in any agency's case. If we look at paragraph 57, it says Article 29.9 and the specific treaty anti-abuse rules included in tax conventions are aimed at these and other transactions and arrangements entered into for the purpose of obtaining treaty benefits in inappropriate circumstances. However, where a tax convention does not include such rules, and then you then have paragraphs 58 through to 61, which again are all dealing with circumstances where you do not have a specific anti-abuse rule. And in fact, 61 is actually just the old 9.5.
Well, except with a specific reference to paragraph 9 of 29.
Indeed, my lady, but that fundamentally that is 9.5. Then paragraph 62 through to 65 are addressing situations in which there are specific avoidance provisions. Again, nothing contrary to HMRC's case in that. And then the remainder of those pages are simply dealing with domestic rules and judicial approaches and how they interact with double tax treaties. Well, none of that's relevant to our case in my submission. My lady, I didn't quite finish my point about deletion. I got a little sidetracked by the principal purpose test. My submission, the fact that it is deleted, in principle, can't be relevant to your construction of Article 12.5 because it was deleted in 2017. That paragraph 21.4 came in 2003. If Article 12.5 in this case had a particular meaning in 2016, or indeed in 2012, that meaning cannot be affected by the fact that a particular paragraph in the commentary has been deleted. The OECD has set out what that kind of provision means. It's relevant to the extent it's relevant, but in my submission, its deletion simply can't alter that fact. Obviously, if it had been fundamentally changed, that might be different, but deletion in my submission doesn't make any difference. I then need to just briefly address you on the conduit report. You already have my submission that in the commentary, conduit situations are dealt with as a separate situation. The Upper Tribunal placed significant reliance on the conduit report. You can see that in particular at paragraphs 49 to 51. It's page 101 of the core bundle. I don't propose, given the time, I don't propose to read it now, but if I just flag it's paragraphs 49 to 51, first mentions the conduit report in 49 and then goes on to draw some conclusions from it. In my submission, there was absolutely no basis for either the Upper Tribunal or for my learned friend to rely on the conduit report in any way. It is simply not relevant to this case. You can see that most clearly, page 863 of the authorities bundle, which is the second page of the conduit report. Paragraph 2, perhaps unsurprisingly, says that the conduit report is dealing with conduit company situations. Now you have my submission, Article 12.5 is not limited to situations involving conduit companies, and nowhere in the conduit report does it address a provision in the form of Article 12.5. Now, the commentary we do have, paragraph 21.4, was inserted in 2003. That is 17 years after the conduit report was adopted, which, for your note, is on page 862 of the authorities, but it was the 27th of November 1986. So, conduit report couldn't possibly have been addressing that bit of the commentary in any way, because when the conduit report was published, that commentary didn't exist. Moreover,
so conduit report 1986.
1986,
and the commentary was
the
first
21.4, the relevant paragraph was put in 2003.
Yeah.
It's at the bottom of, I don't propose to go back now, but it's at the bottom of the section. Moreover, there are in the conduit report a number of possible solutions suggested for dealing with conduits, and the UK and Ireland did not choose to adopt any of those suggested solutions. So in my submission, there is no reason, and was no reason, for the Upper Tribunal to infer, or for my learned friend to submit, that the conduit report provides any relevant commentary as to the scope of Article 12.5. I'm very close to the end, my lord. I'm really trying to go as fast as I can.
You are close to the end.
Yes, I had appreciated that, my lord. I can be very brief, my lady. I'm not going to take you there, my lord. But my learned friend said that the First Tier Tribunal had not adopted HMRC's construction of Article 12.5. That in my submission is plainly wrong. I will give you the references. My submissions are recorded by the First Tier Tribunal at 93 to 95. And then the Tribunal's conclusion is at paragraphs 136 to 137. My submission is absolutely clear beyond any shadow of a doubt that the Tribunal did adopt HMRC's construction. Now, of course, if this court comes to a different construction, that may be by the by. But as far as the FTT's careful analysis of the legal position is concerned, that's the construction they adopted. Respondent's notice point. My submission is none of the materials, as my lord identified, say that Article 12.5 or equivalent provisions are limited in that way. I would also commend the First Tier Tribunal's analysis as entirely correct as to why, in particular, the parliamentary statements are not admissible. But unless the have a strong sense that the court might not want me to address them on that, so I shan't. But I entirely endorse the FTT's analysis on that. 2 pages, and then I'm done. May I? I could stop, my lord, now. But
I think we're now past
could I have
the witching hour.
Could I have 3 minutes?
You've got 1 point. Make it.
Let me choose. My learned friend made, I just want to take you to one factual finding. You have my submissions about Fisher. I've made those in full. I don't need to remake those. But in my submission, the reasoning there is of the Court of Appeal is entirely correct. But my learned friend did make one point about the tribunal saying that, well, in setting the price, the parties would have looked at all of these different considerations. If we could, in particular, go to page 192 of the core bundle, my learned friend relied on 164, subparagraph 4. Now, I re-emphasise we are concerned only with BLM's purposes and BLM's perspective. An awful lot was said by my friend about the position of Sickle, but this case is not proceeding on the basis of Sickle's purposes. But my learned friend did say, well, paragraph 1644 at page 192, he said, well, the First Tier Tribunal found as a fact that when it came to setting the price that it was prepared to offer for the side claim, BLM took into account the following. And then it lists a number of considerations. Now, you have my submission that HMRC's case doesn't depend on the specific price. It's all about whether the fact that the transaction would go ahead at all. But I just wanted to make clear that in 4A of that paragraph, where the tribunal refers to, first and most importantly, the quantum and timing of the expected cash flows attached to the SARD claim, the cash flows it's referring to are the payment of interest and the recovery of the withholding tax. So what the court was saying is, most importantly, was its consideration of the quantum of its recovery of the withholding tax. Those are the only cash flows that it can be referring to.
Mr. Kuczynski, if you take particular exception to that point at 20 past 4, then perhaps you can simply give us a contrary reference. But I think we'd better draw stumps.
Yeah, all I want to say is that how much interest they received also depended on the late termination, which the tribunal says in great length.
Right, well, thank you very much. I think we have that. Good. As I said, I think we will stop there. Can I thank both counsel and everybody who has undoubtedly put an awful lot of work into this behind them. Notwithstanding Mr. Kuczynski's mishap, may I compliment the people who put the bundles together for us, which has certainly made our life considerably easier. You won't be surprised to know that we are reserving judgment. You'll probably also not be surprised to know that we'll say that you shouldn't hold your breath in the expectation that you might get it before Christmas. But when we do give you a draft judgment, we'll give it to the individuals whose names have been provided to my clerk in advance. As you will all know, it is designed to enable you to correct grammar or any typographical errors, but not to re-argue points. It comes with, the draft judgment will come with an embargo on the top, which means what it says and which the court takes very seriously. So anybody in receipt of the draft judgment should abide by that embargo. We will, after we have received your suggested corrections, hand the judgment down. You will not need to attend the hand-down hearing. but we will expect to receive by a date which we will set either an agreed order, or if an order is not agreed, then short submissions in writing about the points of disagreement, which we will then resolve on paper. And I think that is all I need to say, other than to thank everybody and to wish you all a very pleasant break if you get one.
Likewise.
Great.
Thank you very much.
All rise, evening.